We are going to get started today with our Medicaid Lookback Ag Professional Continuing Education Program. My name is Tyler Hoffman. I am the Program Development Associate for PA FarmLink. We are a 27-year-old 501c3 nonprofit, and we have a mission to link farmers to the future. Before we get started, I wanted to talk about some of the services that PA FarmLink offers. We have farm succession planning facilitation. We offer a land linking database for farmers and landowners. We have a referral service that we use, a comprehensive list of ag professionals. And then we also provide educational opportunities and resources, including annual ag professional learning opportunities, such as the event you are at currently. In addition to our four main services, we also have the PA FarmLink Academy. The PA FarmLink Academy is a free educational tool that is available to the public. We currently have 8 learning modules on there that cover topics ranging from ag leasing to grants that are available for farmers. We will be adding to the PA FarmLink Academy throughout 2024, so please be sure to check back and take a look at the learning modules that we will be offering. I'd like to take a moment to recognize those who made this program possible. Funding for this program was through the USDA's Sustainable Agriculture and Research and Education Program, and we also got funding from Pennsylvania Department of Agriculture. Thank you to the Penn State Ag and Shale Law Center. Our speaker today is Attorney MacGregor Brillhart of Stock and Leader. Attorney MacGregor Brillhart, a partner in the law firm of Stock and Leader, focuses his practice in all areas of estate planning, estate administration, elder law, and fiduciary litigation. Mac routinely assists with preparing estate planning documents, including wills, durable powers of attorney, living wills and trusts, and estate and trust administration. He also frequently appears before the York County Court Common Pleas in matters relating to incapacity hearings, guardianships, name changes, and adoptions. In the area of elder law, Mac assists clients through the utilization of various Medicaid planning techniques. On April 1st, Mac was named solicitor for the York County Register of Wills and clerk of orphans courts. During the COVID-19 pandemic, Mac oversaw a will probated electronically, the first ever in York County, Pennsylvania. For 12 years, Mac served as the York County coordinator of the Wills for Heroes program, an initiative providing first responders and veterans with fully executed, witnessed, and notarized wills, living wills, healthcare, and financial powers of attorney free of charge. Mac is the current chair of the York County Leave a Legacy York County Steering Committee and serves on the UPMC Memorial Board of Directors. In 2015, the Central Penn Business Journal named Attorney Brillhart one of Central Pennsylvania's 40 Under 40 award recipients for his commitment to business growth, professional excellence, and community service. Without further ado, Attorney MacGregor Brillhart.
Thank you for the introduction. I work for a law firm out of York, Pennsylvania, but we serve Adams, Dauphin, Lancaster, York County, and my particular area of practice is trust and estate law, and particularly elder law as it relates today to the presentation. So I'll spend very little time on the really basic information here because I know folks want to learn more about the Medicaid Lookback and some asset protection strategies. But 3 simple documents we think everyone should have in place relate to a financial power of attorney, which would be a document where you're nominating someone to act for you if you become incapacitated. We do a lot of Medicaid planning, asset protection work within the financial power of attorney. If you think of a person that goes to a nursing home for skilled care, they are generally incapacitated when that happens. And so a lot of the maneuvering we use is under that financial power of attorney. So I'll talk about that in more detail. Healthcare power of attorney and living will would be similar to the financial power of attorney, in which you nominate an individual to make medical decisions for you if you're unable to do so, as well as end of life treatment. And then, of course, your last will and testament. And we'll talk very briefly about the utilization of trusts, both in and outside of the will. Just an important piece to note, and this relates to the Medicaid recovery program. Your will does not cover jointly owned property. So for instance, if I own a farm with my wife and I die, my wife would become the de facto owner of our farm by being a joint owner on the deed. Similarly, if I have an asset such as a life insurance policy or a retirement account or an investment account that bears a beneficiary designation, so I fill out a form with MetLife and I say, when I die, my life insurance goes to my wife and kids. That form itself, that beneficiary designation, overrides the will as to where that money goes. So those two buckets of property are not controlled by the will. Why is that important in a farm context and a Medicaid recovery context? When an individual is in a nursing home or receiving nursing home benefits at home, that program, Medicaid, or in Pennsylvania, we call it medical assistance, has a recovery piece to it, meaning that Medicaid is keeping track of the dollars that they pay out for the individual, and they will come back when someone passes to try to collect what they've paid out against that person's estate. What that means is if the farm passes jointly to my wife and she's the owner and the farm does not come into my estate, Medicaid cannot recover against the farm, leaving the farm free of its lien. Trust agreements, briefly. We use trust for all sorts of reasons, but a very basic explanation would be the idea of certain trusts are created and actually funded while someone's alive, which you'll refer to as a living trust or an inter vivos trust, versus a trust that is under one's will. So if I have a trust within my will and I say, when I pass away, my children inherit at 25, 30, 35, those are age trusts that are contained in my will. And therefore they don't come to fruition until my death because they're in the will. Whereas if we create a trust, transfer real estate into it when we're alive, we're creating an inter vivos trust, not a testamentary trust. How does that relate to farms? If you use a revocable trust, okay, these bottom two bullet points are both inter vivos trusts. They're both living trusts. So if I create a revocable trust and I transfer my farm into the revocable trust, the fact that the trust itself is revocable means I can change my mind. I could take my farm back. I could put the farm back in the trust, take it out of the trust, put it back in the trust, take it out of the trust, because it's revocable. Because it's revocable, I haven't really given up any right to my farm because I can take it back. Because I haven't given anything up, that revocable trust does not protect my farm from a nursing home. And so there's no concern of a 5-year look back in that example, because of course, again, I haven't even given up my farm. I can take it back. Therefore, if I go into a nursing home and my farm is in a revocable trust, it is accessible for Medicaid purposes. Also on recovery, if that farm were exempt when it was in a trust and I was able to retain it and not sell it for skilled costs, my farm that's inside this revocable trust would be lienable at my death by the recovery program versus an irrevocable trust. So we should be able to tell the difference right between the two. If I put my farm in an irrevocable trust, I cannot get it back. I've put it in the trust. I no longer own it. The trust owns it. And because it's irrevocable and I no longer own it, the nursing home cannot attach to it. However, there's a 5-year look back. So if I place the deed of my farm into my irrevocable trust and I go into a nursing home a year later, we have a 5-year look back on that gift. That's problematic. Of course, if I make it 5 years from the time of the deed transfer to the time that I need skilled care, I will have beaten the 5-year look back, and therefore the farm would not be accessible for nursing home purposes. Also, when I pass away and that Medicaid lien comes against my estate, it would not attach to the irrevocable trust because that is not in my estate. A little bit about inheritance tax, and there's some exclusions regarding farmland, but general inheritance tax law in Pennsylvania, a lot of folks don't realize that you earn money in life and you pay income tax and you die and they tax it again. People are very unhappy about that. So for purposes of inheritance tax rates, if I leave money to my wife or a qualified 501c3 charity, or my children are under 21, there's no transfer tax for inheritance tax purposes on those transfers. Whereas if I leave money to my children who are over 21, grandchildren sort of going down, lineal descendants are going up, parents, grandparents, those rates are 4.5%, which is 4.5% of the value of the estate, includes everything except for life insurance. So my glasses, my car, my house, my 401k, my bank accounts, my investments, they're all subject to this tax rate. Siblings pay 12%. All other individuals pay 15%. Farmland exemption. Historically, you'd hear about farming families being, rich in land and potentially poor in cash. And so this inheritance tax could really crush a family farm. What happens when the kids inherit the family farm and it's subject to this tax and there's no money? The farm has to be sold. So good piece of legislation here to exempt that and not cause fire sales of farms. And so the land itself is exempt with, it's pretty simple process to exempt that on an inheritance tax return. That's we'll call that the easy exemption. The more difficult exemption is the second exemption, which would be the land and the buildings. So if I want to exempt both the land and the buildings, barns, houses, things that are built on the farm, there are rules to that. One of them being that family members have to receive it. They're defined under the statute of what a family member is. And also, once they receive it, they can't sell it for 7 years. So the government will create certifications that you still hold on to it annually and that you haven't sold it. If you sell it within 7 years, they want their tax. And you also have to prove that it's actually being farmed and producing income with an income limit. So you can imagine very, very valuable farms in South Central Pennsylvania. We are exempting millions and millions of dollars worth of farmland through these exemptions. Speaking of tax, there is also a federal death tax in addition to a state inheritance tax, yet another tax. And this tax right now relates to very few people because we all have sort of describe it as a magic halo above your head that we all have roughly a $13 million exemption. So I don't know about everybody else out there, but I think I'll be okay on this one. And so when I pass away, if my estate is under $13 million, I have no federal estate tax. And if you're married, you have $26 million of exemption. Each spouse has an exemption. And another nice piece of tax legislation here is if my wife passes away and doesn't use her exemption, I can inherit her exemption at her death. It's portable. And I now have two exemptions so that when I die, I still have $26 million of exemption not lost on my wife's death. Gift tax. And this can relate to the transfer of a farm. So this has changed over the years. It was 12, it was 15, it was 16, now it's $17,000. You can gift $17,000 to anyone, doesn't have to be a family member, per year. So I could give my friend $17,000 on December 31st. I could give my friend $17,000 on January 1st. And we do that for estate planning purposes quite a bit. There are gifting exemptions that do not have a $17,000 cap if you're paying for qualified tuition costs or medical expenses. So if I pay for my child's college, for instance, which is more than $17,000, I haven't broken that exclusion for those qualified purposes. And then this last part gets a little technical to explain. If I transfer my farm to my son and my farm is worth $500,000, I have clearly broken my $17,000 exclusion. So I went over by $483,000. When you go over the exclusion, you have to report that to the IRS on a gift tax return. And you're telling them, hey, I went above the 17. It's an honor test, although I'm sure they could track you down if you don't report it. And when I report that overage of $483,000, I go back to this halo I have above my head of 13 million. The IRS will reduce my halo from 13 million to 12,500,000. So I'm still probably going to be okay. But you have to report such a gift so that your halo is reset by the IRS. So considerations about gifting of a farm to talk about briefly here. Of course, it sort of goes without saying, but loss of ownership. We deal with this a lot, whether it's a farm or it's just a traditional piece of real estate, where people come in and say, I don't want my kids to pay inheritance tax, and so I want to put my house in their name, put my house in my children's name. So when you do something like that and you gift an asset like a farm to someone else, the world now thinks that that person owns it. Well, they do own it. And so if I take my parents' house or my parents' farm and I own it, but they're still on it and they still consider it their house because they live there, and I get divorced, that asset is subject to my divorce. If I am driving on Route 83 and hit someone and hurt them and they sue me, my parents lose their house. If I die, my parents thinking they own that house isn't their house. It goes into my estate, goes to my wife. So if I go into a nursing home, the nursing home could take that house. So the whole concept of people simply saying, let's put the farm in the next generation's name or put the house in the next generation's name, it's a loss of ownership. And, you know, when you don't own the asset, the new person that owns the asset, if they do bad stuff in the world, you lose your asset. So that should be taken very seriously. Also, if the parent relies upon farm income and the child now owns the farm, that income doesn't go to the parent, right? It goes to the owner child. So these are sort of obvious, but need to be considered. A gift of a farm, whether it's outright or into a trust, again, has a 5-year look back. So if I transfer the farm to my child and I fall and break my hip, I develop dementia, I go into a nursing home, that transfer of the farm to my child is caught in a 5-year look back. And we'll talk about what happens when you get caught in a 5-year look back. Another big consideration on gifting farms is the loss of a step up in basis. So if I buy my farm for $100,000 and I sell my farm for $1 million, let's suppose it's not my primary residence, I have a capital gain of $900,000. And so that's a huge gain. What the IRS does is they incentivize people to inherit, not gift. So if I have that same farm that I bought for $100,000, it's now worth $1 million, and I don't gift it, and I retain ownership of it, and I die, and my kids inherit that farm, they get a step up in basis. So now when I die, we say the farm's worth $1 million, and my $100,000 purchase price goes away. My kids inherit it at $1 million. If they were to turn around and sell it, they'd have no gain, right? So this step up in basis is huge. And when you gift the farm, instead of waiting and having them inherit it, the transferee that takes the farm, my child, the new owner, gets my old basis. And then they're stuck with that old basis. So the loss of basis can be significant. And then, of course, we talked about this idea of making the gift, and the gift is greater than my $17,000. And therefore, that overage will reduce my halo. And so my state exemption, if I need it, would go down. You might say, well, if I have a $13 million exemption and I have $1 million farm and it goes to 12 million, I'm still going to be okay, because most people don't have $12 million when they die. But this exemption can change. And there's even been talk about it being changed and going to as low as 3 million from 12. So even though you think that the current value of the halo might not apply to you, there could be future changes in the exemption level that could impact you. Talk a little bit about Medicaid and Medicare now, which is the sort of purpose of the program. And I even have lawyers that use these interchangeably, and they shouldn't be used interchangeably. They're vastly different programs. So Medicaid, which is what we're talking about today, is a federal program that's administered through states to provide cover the cost of skilled care for what we would refer to as a nursing home. And we'll talk about levels of care. And to apply and become eligible for Medicaid, you have to be both financially needy and medically needy. So to try to boil this down and make it simple, if I go into a nursing home and I am broke, but I am not sick, the government won't pay for me. I'm not sick. I don't need to be there. If I go into a nursing home and I'm sick, but I'm not broke, the government won't pay for me because I'm not broke. So you have to meet these two prongs, meaning that your assets it's an asset test, not an income test, that your assets have to be below a threshold of $2,400. That can change a little bit depending on your income, but that's the lowest level. And you have to be certified to require skilled care, 24-hour care in order to meet the medical prong. Once you meet that prong, virtually everything that you need inside of a nursing home is covered. Anything from bedding to food to medicine to nursing care is covered. And you'll hear the term medical assistance used in Pennsylvania, which means the same thing as Medicaid. Medicare, we know, is a health insurance program for people over 65. You don't have to qualify for it other than to be 65. Once you're 65, you qualify for it. There can be a little intersection between Medicare and Medicaid. If I'm admitted in a hospital, keyword admitted, and we've seen hospitals have people in the hospital for days and somehow not admit them. I don't know how that's possible. But once they're admitted, if they're admitted for 3 days and then they get better and they go to a nursing home, there are some Medicare coverages for the first 90 to 100 days through Medicare. In reality, what I see in my practice is if people are rehabilitating in a nursing home, they will get out. But if they're not actively rehabilitating, which is the large amount of people, they're not going to rehabilitate. They're going to stay in the nursing home probably forever. And if they're not rehabilitating, Medicare typically will cut off at 20 days. Talking about those levels of care, again, Medicaid, I just did it. Medicaid will cover skilled care only. So we have folks coming to us trying to do Medicaid planning when someone is in a personal care home or assisted living. We can still do planning, but if you're in assisted living, you're not eligible for Medicaid. That's not skilled care. That's assisted living or personal care. You're more so in need of an aide than a nurse. And then we have, so the 3 levels: independent living, you live on your own; assisted living or personal care, you live in an assisted living facility; and then skilled care would be a nursing home. There is a program in Pennsylvania now, and we're seeing more and more of it, where people require skilled care, but they don't want to live in a nursing home. And so you can apply for Medicaid while you're in your home, while you're living on your farm. And Medicaid through Pennsylvania will pay for nurses to actually come to your home and provide nursing care in your home. It's called the Medicaid Waiver Program. The downside of that waiver program is that it's not 24/7. So you're not going to have somebody with you 24 hours a day like you would in a nursing home. The hours have to be limited in the waiver program. Some statistics on long-term care. The statistics are showing now that 69% of people over 65 will require some skilled care. And so that's almost 70%. And when people require that care, the average duration of that care is 3 years. So we're seeing, extremely lengthy stays for, a 70% of that population. You can see why this is becoming an issue to be talked about. We also want to make people aware of admission agreements. So nursing homes, and we will refer to them as campuses, where someone goes into a campus and there's a cottage and then there's assisted living and then there's skilled care. They want you to disclose your assets when you become admitted there, and therefore they give you admission agreements to sign. And those admission agreements should be carefully read. There are exceptions. I'll talk about them when we go through some hypotheticals, but for instance, there's no 5-year look back when you have a transfer from a spouse to spouse. So if I go into a nursing home and I own a farm, potentially my wife can take my name off of the farm and put the farm in her name, and there's no 5-year look back because we're married. So these admission agreements will sometimes say that when my wife signs me in to the nursing home, that there will not be any gifting. Well, we don't want you to sign that because you're allowed to gift spouse to spouse. And so if these admission agreements are trying to prohibit what is legal, we don't want you to sign them. So just be wary of admission agreements, and good idea to have someone that's familiar with these rules, which is the next bullet point, look at it. Likewise, as in most areas, we think you want to deal with an attorney that specializes. You can see these rules are confusing and technical. And so I wouldn't want to go to a divorce attorney to help me do elder law. And I wouldn't want I wouldn't give advice on divorce law the other way around. You should go with someone that practices in that area every day and knows it in and out. We also use, I often refer to them as caregiver agreements. And so whether you're a farmer or not, this is a way where mom or dad lives with child, or child lives with mom or dad. And by child giving care to parent, they're keeping their parent out of a nursing home or out of an assisted living facility. And so if I take care of my mother and she pays me $1,000 a month and there's no agreement in place, that's considered to be a gift. So I can no longer take care of my mother. She goes into a nursing home and there's a 5-year look back, and they look at her bank records and they see she's paying me $1,000 a month. If there's not an agreement in place, that's gratuitous, and that would cause her to be caught in the 5-year look back. So by putting together a pretty simple agreement and saying, I pay my son $1,000 a month to take care of me, that might seem odd that family members are paying each other, but it's a way to protect assets from long-term care costs because those aren't gifts, they're in a contract. So we use caregiver agreements pretty frequently. We also use rent agreements. Another exception we'll talk about from Medicaid standards would be income producing property. So whether it's a beach house or it's a farm, if we can show that a property is being rented, we get an exclusion from Medicaid because it's income producing. Talk a little bit about long-term care insurance. It can be very helpful. There's even a program in Pennsylvania that specifically relates to long-term care I'll talk about, but we're finding, long-term care insurance is very, very expensive. And so I've had a number of clients that have been paying on long-term care insurance for decades, and they're getting notices now when they're in their 70s and 80s and 90s that their premiums have doubled. And even though the contract was signed and the premium was identified, the premium changes, and they're put in a position where I've been paying on this for 20 years and now I can't afford the premiums. And so, we're skeptical about some of these older policies, how well they were underwritten, to keep an eye on that. We also want to be wary of what are called elimination periods in long-term care insurance, where I go into a nursing home, but my policy has a 100-day elimination period. So that means that long-term care won't pay for me for the first 100 days. The policies also have benefit triggers. So that can relate to, I've seen long-term care insurance pay for assisted living and skilled. I've seen it only pay for skilled. So, and I'm not an insurance professional, but you want to be understanding when you purchase long-term care insurance that you're talking to someone that is versed in that and is not just a salesperson. There's also limits on long-term care insurance often. So some of them have dollar limits where they'll pay $300,000 and they cut off. Some of them have duration limits where they pay for a year or two and they cut off. So be wary of limits in long-term care policies. Another thing I've seen helpful in those long-term care insurance policies is the person that owns the policy buying what's called an inflation rider. So when they bought it 30 years ago, a nursing home was $60 a day. Now a nursing home is $375 a day. And so there's inflation built into it so that the coverage continues to increase as the cost increases. Usually there's an additional cost for that, but it can often be worth it. Last part on this slide is the long-term care partnership program. And so Pennsylvania is encouraging people to buy long-term care insurance. Why? Well, if the person has long-term care insurance, they're less likely to have to lean on the government to pay for them. And so if I have a long-term care insurance policy and it pays for $100,000 of nursing home expense before I qualify for Medicaid, when my long-term care cuts off and I apply for Medicaid, Medicaid will allow me to retain $100,000 of my money equal to what I got from the benefit. Okay, so let's start to talk a little bit about what we can exempt when we apply for Medicaid. So there are just de facto exemptions that are not eligible for spend down, meaning you get to keep them. Government can't take them, nursing home can't take them, you get to retain them. And the easiest way to talk about that is to go through what's not countable. So not countable means if I go into a nursing home, I can keep it. And so things like household goods and furnishings, clothing, jewelry, the government is not going to make you sell those things in order to pay for your care. They're exempt and they're too difficult to track anyway. Your primary residence, this is a big one, especially if you live on your farm. Your primary residence is exempt from Medicaid spend down. One vehicle is exempt from Medicaid spend down. I have a note on the primary residence that you need to intend to return. That's true, although I would argue that even the sickest of people, when they go to a nursing home, if they could return home, they would. So I've never had any concern about completing a Medicaid application and checking that box. Even if it's unlikely for my client to go home, I know somewhere in there they want to go home. So I've had some people say, I can't believe you checked that box. That's never going to happen. I don't lose a lot of sleep on that. Yes. Yep. Whether there's a spouse or not. So good question. If I go to a nursing home and I own a farm and my wife continues to live on that farm, obviously she needs it. And she can be there and pay for it and live there. If my wife's deceased and I go into a nursing home, now there's nobody in my house, right? So you can still exempt it because I intend to return to it. Then the question becomes who's going to pay for it when I'm in the nursing home, which is a different issue, but it's still by definition exempt.
Is there a maximum value allowed on the primary residence?
Yeah, it's $500,000. Good question. But there's a tie into that related to the farm that I'll talk about in a minute that can get you over and above that amount, because I know we have farms north of that amount. There is also, I said one vehicle exempt. And if you've prepaid for your burial, funeral, marker, those things are exempt. They're not going to make you sell your funeral plan. We'll get into the farm here a little bit. You'll hear me use the term community spouse. So the community spouse would be the spouse that's not in the nursing home. They still live in the community. My spouse's retirement accounts are not accessible. So if my wife has an IRA or a 401k or a 403b, the nursing home cannot attach to my wife's retirement accounts, but can attach to my retirement accounts as the person that's admitted. Term life insurance, as it has no cash surrender value, typically is exempt. And then life insurance that does have cash value has some small exemptions. Relating to the farm, they're going to use the terms here, real or personal property used in a trade or business, essential to self-support. Okay, so that's a farm with income, and the farming equipment, even the livestock, they're all things that we can exempt under the business exemption. So even if the primary residence limit that was referenced is too low, we can exempt the farm under an additional exemption. So the 5-year look back, the scary 5-year look back. This is, if you've ever dealt with this, the county and state offices, they really do go through the person's bank statements one by one for 5 years. I can't imagine having to do that all day, and they're looking for transfers on a bank statement that are greater than $500. If they're under $500, they're not typically looking at that, but they're looking for gifts, and, you know, transfers of real estate, things of that nature, which wouldn't appear on a bank statement. And they're looking back 5 years. When they find a gift that's been made within 5 years, they're going to impose a penalty. And so we talk about a little bit, I think this is a little wordy, I'll just put a hypothetical on it. Easy way to think about how this rule works is if I give my son $100,000 and it gets caught in the 5-year look back, we use the amount of the gift as the numerator, right at the top of go back to middle school division, and you divide by, I'm going to use a really easy number for my math purposes, the average cost of a nursing home in Pennsylvania. Let's say that's $10,000. So we have $100,000 divided by $10,000, which gives us 10. 10 what? 10 months. So because of this gift to my son for $100,000, there's a 10-month penalty where Medicaid will not pay for me because of the gift. If I gave him $200,000 in my example, that would be a 20-month penalty, and so forth. If I gave him $20,000, it would be a 2-month penalty. So this is a penalty that hurts, right, the person going into the nursing home. My son's already got his 100 grand. He's went off and spent it. And now I'm sitting here and I'm penalized because of this gift. If the child would return the money, which in my experience does not happen, then the penalty can be cured, right? And so all of a sudden my son gives me the $100,000 back and the gift went away. Simple enough. If he doesn't return the money, now we have a problem. I'm broke. I don't have money to pay the nursing home. Medicaid won't pay for me because of the penalty period. So those are really extreme and sort of dramatic examples, but they happen. In fact, one of the hypotheticals we go through is a gift of a farm and what happens when that gets caught. Okay, there are some transfers or gifts that are exempt. This planning world is full of exemptions to learn. If I gift money, transfer my farm, transfer real estate to a child that is disabled or blind, there is no 5-year look back on that. And we've done that specifically to exempt real estate, for instance, taking the theory being that disabled child, because they're disabled, they can't work potentially. And because they can't work, they can't provide for themselves. And so this is providing some benefit to a disabled child or a blind child. The big one that we use most, whether it's a farm or not, is a transfer of an asset to a community spouse. So again, this example of my wife and I own a farm and I go into a nursing home and my wife and I are on the deed, I can have my name removed from the deed, put into my wife's name. Now you say, well, wait a second, that was your house or that was a farm with income, so it's exempt. So you didn't even have to take your name off it if it's exempt. But the reality is, if we play that through, if I remain on the deed and my wife dies first, I become the owner of the property because I'm on the deed with my wife. And when I become the owner of the property, I'm in a nursing home. It's still exempt despite the fact that I'm in a nursing home, but when I die, it's in my estate. And when it's in my estate, Medicaid recovers against my estate. So that's a lot of facts there, but by taking my name off the deed and my wife owns it, there's no 5-year look back because it's spouse to spouse. It's exempt. My wife gets to keep it. And now when my wife dies, it's not in my estate. and therefore Medicaid can't recover against the farm. When we change the deed, we change my wife's will at the same time. So we say, we need to put this deed in the healthy spouse's name. And when we do that, we write a new will for the healthy spouse. And we say that not for lack of love, but we're going to write my husband out of my will, and we're going to slide my kids up. And so when my wife dies, if I'm still around in the nursing home, I don't want to inherit money, right? If I inherit money in the nursing home, we got a problem. So we're taking that sick spouse out of the will and sliding the kids up in that example, which ultimately gets that through my wife's estate and not subject to my recovery.
Can the trust for benefit of disabled child have other beneficiaries as well, or the ability of the trustee to transfer any of the assets to able-bodied children?
Yeah, you can have multiple beneficiaries of one trust. When we do special needs trust for disabled individuals, we typically use trust shares because the rules of beneficiaries are different, whether the person's disabled or not. So let me give an example. If I have a disabled child and an abled child, and so my fear is that when I die and I leave money to my disabled child, if he or she touches the inheritance, he or she will lose their government benefits, right? So they could lose their housing, they could lose their SSI, they can lose their Medicaid. And so we want that money to sort of go over the disabled child's head into a trust. And therefore the child hasn't touched it, hasn't owned it, and they get to keep the benefits that the government's paying them. And also they have this trust over here that they don't own, and we can pay for supplemental needs for the disabled person out of that bucket. And perhaps I have a trust for my non-disabled child. To give an example, I have 3 children, and my will says that when my wife and I die, they get a third at 25, a third at 30, a third at 35. Those are just little kids will blow money trusts. And so that's different than the special needs trust, has different terms. Back to your question, we would have this share be particular for the special needs child because of the different rules. And at the death of the special needs child, it would pay back to the able child, is how we would set that up. And we even have language that says, if this trust gets challenged by Social Security or Medicaid, we want the trust to terminate and pay to my able child so my disabled child doesn't lose his or her benefits. Okay, let me repeat the question. Thank you. Question was, if there's a transfer from a spouse to a spouse, and now the healthy spouse owns the property, can that spouse make transfers to their children, for instance? So once someone's on Medicaid, there are sort of annual checkups on the person on Medicaid, but the annual checkups don't relate to the spouse that's not on Medicaid. Does that make sense? So I'm not seeing tracking of what the community spouse does after the spouse is on Medicaid. They're going to check on that spouse to make sure that they should be on Medicaid, but they're not checking on the community spouse. However, and I think this is what you alluded to, if I go into a nursing home, I gift my residence to my wife owns it, and she then gifts it to our children, she has her own 5-year look back recreated. Yep, good question. Other exemptions here that we've used: transfer of the home. Oh, sorry, I talked about that one already. Sibling. This is very specific. Transferring a home to a sibling who has an equity interest, meaning that they own the property with you. If I own my property and my sibling is not on my deed, they have no equity interest. And that we were residing in the home for 1 year together before a nursing home. I think the theory there is, if my sister lives with me and owns the house with me and is living with me before I go into the nursing home, probably her helping take care of me kept me out of the nursing home. That's the concept there. This last one we use a lot, and it's going to come up in some of the farm hypos. Transfer of the home to an adult child, just a child, who has resided in the home for at least 2 years prior to the admission of a nursing home and provided care. So I move in with my dad. He has dementia. I provide care to him. And by me being there, he doesn't have to go to a nursing home. Government doesn't have to pay for him. We're saving the government money here. That's why they let you do these things. And so because he didn't go there, I kept him in the community, kept the nursing home cost away for 2 years. I have to live there. We typically get a letter from a doctor on this. So if you think about it from the lawyer's perspective, this is pretty scary stuff, because I'm telling a client, we're going to go ahead and deed your house from you to your caregiver's son, like when you're going in the nursing home. So we're well within the 5 years. And so we get a letter from a physician, and the physician writes the letter and says, Johnny was living with dad. I'm aware of that. If Johnny wasn't living with dad, it's in my doctor's opinion that dad would have had to go into a nursing home. So when we apply for benefits, we give the doctor's letter to the county to show why we did what we did. That can be hugely helpful. I don't have a lot of interaction with the doctor and getting the letter. The family does that. I believe sometimes we have some very, very friendly doctors out there that, love their patients and have taken care of them for 50 years. And I'm not sure that I'll leave it at that, but the doctors want to help. So the question was, if a parent becomes elderly and is not maybe as active in the farm operation and the income is going to the child, can you truly represent that it's income producing if the parent that owns it doesn't get the income? Is that the question? So I'm trying to be diplomatic how I say this, because I don't know who all is in the audience. So I think it's unlikely that the IRS touches Medicaid. So I think it's a self-reported thing. And I would be surprised if medical assistants would get in touch with the IRS to see if it's reported. That would be stunning to me. But I do think that ideally, you got to always put the 1% CYA on this, that to be perfectly safe, I think some sort of sharing a contract and showing some income go in would be ideal. Good question. Oh, I wanted to go back to this idea, and this might be one of the more important things to take away from this session. When I own a farm and I go into a nursing home and my wife and I are on the deed and there's no 5-year look back between spouses, so we take my name off the deed. That's sort of a simple explanation. In reality, how does that actually happen? Someone has to sign a deed to take my name off of it. Okay. My wife could not right now take my name off or the deed to my house without me knowing. I sure hope not. And typically the person that's coming off the deed signs and says, I don't want to be on it. Well, what you have in this world is 98% of the time, these people are incapacitated. And so, they're cognitively not there. And I've met with a lot of people, my partners here, we meet with people probably weekly that are incapacitated. And it's a very difficult thing to meet with someone and you want to help them, but they don't understand. They don't know their name. They don't know their address. And, we can't help them. They can't sign things. And the common thing will be, no, he can still sign his name. That's not the test, right? The test, you couldn't even read my signature, but the test is not, is it legible? The test is, does the person understand the act? So going back to this example, and this is the takeaway, I went back to the beginning of the presentation where I said, how do we act for people when they're incapacitated? Through a power of attorney. So I have a power of attorney. I'm 44 years old, and this might sound morbid, but because I deal with death in nursing homes every day, maybe I'm paranoid. In my power of attorney, I say, if I become incapacitated, my wife can handle my finances. And that everybody understands that. It's sort of simple. Sign checks, sign a tax return, deal with the bank, sell a car, everyday stuff that I would call sort of mundane everyday stuff. And in this type of planning, we use this term, it sounds silly, but we include what are called superpowers. And these superpowers are, I'm giving my wife more than the mundane stuff. So in my power of attorney, even at my age, and I'm not hopefully going to nursing home anytime soon, but I say if I require skilled care, my wife has an unlimited gifting power. So think about that. Letting somebody sign something for you is one thing. Letting them take all of your money and give it to themselves is a whole nother issue. So, maybe if I was on my 9th wife and she was 19, I wouldn't give her the superpower, right? But I trust her and I give her the superpower. So at that point, when I go into a nursing home, my wife uses my power of attorney to remove my name from the deed. Okay. And that power has to be explicitly put in the power of attorney. And if you look at most powers of attorney, they have this laundry list: banking, insurance, tax. They don't have superpowers. And where I get, sort of sad when we meet with people and I'm looking at a power of attorney from 1987 and there's no superpowers in it, I have to tell the wife, I'm sorry, we can't put the house in your name. Your husband lets you sign stuff, but he didn't let you take all his money. And then, of course, the wife says, would you go out to the nursing home tomorrow and do another one? And then I do go out to the nursing home and the person is incapacitated. And so we're stuck. So the takeaway there is you want these Medicaid planning superpowers in your power of attorney to help preserve the farm. But you only give those powers out to people that you trust. If you don't trust your wife, you probably shouldn't be married to her, but you certainly don't want to give somebody powers that if you think they'll steal from you. So going back to, I go to a nursing home, and I own a farm. We put it in my wife's name through a POA, through a superpower gifting. We exempt that. We exempt a vehicle. We exempt my farm equipment. We exempt my livestock. We exempt term life insurance. We exempt my wife's retirement accounts. We went through all that. Now there's countable stuff. Countable stuff, and this does not matter how it's titled. I can't tell you how many times I meet with people, they say, I never put my husband's name on that checking account. That's not his money. If you're married, it's his money, and vice versa. So your bank account money is countable. No way to hide that. No way to exempt it. My retirement money is countable because I'm the sick one. My wife's is not. And basically any investment money we have is countable. So I talked about the house, the car, the farm. Let's say that, and this is a little technical, I go into the nursing home. My wife and I have $100,000. There's a floor and a ceiling here. So if you split that number and you're between the floor and the ceiling, we split it. So we have $100,000. We split that. The split is 50,000 and 50,000. That 50,000 is between those two numbers. So I get to keep 50,000 that the nursing home is going to try to take, and my wife gets 50,000. So my wife gets that $50,000 in addition to the farm, the car, her retirement. You can see there's a nice checklist to help the spouse. So that's how this works on the split of cash and investments that are countable. If I go into the nursing home and I have $500,000 and we split that number, that 250 is not between the floor and the ceiling. And so at that point, my wife only gets 148,000. Okay. So let's say it's 150 for my math. My wife gets 150, I get 350. Okay. So that nursing home's looking at the 350, my wife gets the 150. Other way around, I go into the nursing home and I have $31,000. Okay. We do the split. It's 15,500 a piece. It's not between the floor and the ceiling. My wife gets the first $29,000, $30,000. So in that example, my wife would get 30 and I get 1. That's how that works as far as splitting investments in cash. Talk about income for a minute. We've been talking about assets. This is income. We refer to this as the MIMNA, and the MIMNA is how much income my wife can get. Okay. So I'm now on Medicaid. The government is paying the nursing home freight. Let's say that my Social Security is $3,000 a month and my wife's Social Security is $1,000 a month. My wife is entitled to the minimum MIMNA. So if she has $1,000 and she's in the community now and she's lost me, I'm not there to help her anymore financially, she would get $1,465 of my Social Security to get her up from 1,000 to the minimum. So my income, which was 3,000, goes down by 1,465, right? So my income's down to 1,600 bucks now. The nursing home gets my remaining Social Security. So my wife gets to get up to the MIMNA, and then the Social Security that I have left goes to the nursing home. If you think about that, that's not a bad deal. If I'm paying $12,000 a month for a nursing home and I get on Medicaid and now they get my Social Security, that's a lot better than paying $12,000 a month.
There's a question in the chat. If your money is in an IRA, are taxes deducted for that calculation?
Taxes deduct? No, they're not. No, great question. They're not. It is the, and I'm going to show an example on an IRA in a few slides. It is the value of your IRA as of the day you're admitted to the nursing home. And I understand the question, and it's a good one. Well, my IRA is not, if I have a $300,000 IRA, it's not worth $300,000. I got to pay income tax on it when I take it out. The government does not give you that benefit, not by a long shot. We made this point earlier, about to get into the hypotheticals here. My probate estate is what is recoverable. So let me go back to an example. I go into a nursing home and I'm going to say that the government is paying about $5,000 a month to the nursing home for me. Okay. So I'm there, I'm private paying, I'm paying $12,000 a month. I get on Medicaid. Now the nursing home doesn't get $12,000 a month anymore because I'm on Medicaid. They get my Social Security and they get a government payment from Medicaid to pay the nursing home. And let's say that's $5,000 a month. If I live in that nursing home for a year and then I die, we had $5,000 payments for 12 months. So the government's paid $60,000 out. This is the recovery program. I die, Medicaid stops. And my family will get a letter from Department of Human Services in Pennsylvania that says Mac is dead and Mac's estate owes us $60,000, right? They're reclaiming what they paid out. And if you think about how Medicaid works, I had to be broke to be on Medicaid. So when I die, I shouldn't have any money. And so we can go back to the government and say, yeah, we got your letter, but we don't have any money to pay you. And therefore the lien goes away. Okay. Going back to my example, you know, if my wife died and I owned that real estate or my farm and I die, the farm's exempt while I'm alive because it's income producing. When I die, the farm is in my estate. The recovery goes against the farm. So the way that we write wills and the way that we title things is critical to getting around this. You know, protecting assets when someone is alive is the first step. And the second step after someone is approved for Medicaid is how can we protect their assets when they're deceased? So we're looking for protection during life and death. This gets a little technical, but the way that we protect money in a spousal situation is through the use of a Medicaid annuity, or as one of my favorite clients called them, Medicaid annuities. And so she was an elderly woman and she was great, but that was pretty funny. So I go into a nursing home and I have these assets. And we've talked about what's exempt and what's not exempt. So on the left side, my wife gets to keep the farm. My wife gets to keep the farm equipment, the livestock, a vehicle. TPP is tangible personal property. Oh, sorry, my wife would be in the nursing home here. I switched genders. My IRA, because I'm at home, is exempt. My income is exempt, term life insurance, and that protected share is that 50-50 split. So I get to keep all that. That's not bad. And then on the right is what's exposed. And what's exposed is my wife's IRA and an investment account and some bank money. Let's say that my wife's IRA is 250 and we have a joint investment account of 200 and a bank account of 200. So there's $650,000 there that is up for grabs. What we have there is I'm allowed to keep, remember we go back to that 50-50 split and the floor and the ceiling, I'm allowed to keep 148,000, okay? And that means my wife gets 502,000. And that means that she is not eligible for Medicaid. What do we know about Medicaid? You got to be financially needy. If you have $502,000, you're not financially needy. And she has to be spent down. My SD is she has to be spent down to $2,000. So she's over by $500,000. So what does my wife have? She has $500,000 that the nursing home is looking to attach to. And Medicaid won't pay yet because she has $500,000. She's got an IRA of 250 and she's got 250 of cash. So what you're able to do here, and this is always stunning to people that this is legal, but I assure you it is, that we can purchase what are called Medicaid annuities. I'm not a financial person. I don't sell annuities. I don't make any money at this. This is how to help the client. We take the money on the right because it's not in an IRA. And if you know anything about taxes, you can't be mixing money that's taxable and not, right? My IRA, I got to pay tax on my IRA when I'm old and I take the money out. So that has not been taxed yet. So you can't mix those. So on the right, we take the $250,000 and we buy a Medicaid annuity and literally write a check for $250,000 to purchase this annuity. Now my wife doesn't own the 250, she owns an annuity in place of the 250. But that annuity is allowed to be paid to me, the spouse. So even though it's her money and it's supposed to be spent down to zero by paying the nursing home, we're protecting $500,000 through this illustration of buying this annuity. So she gives $250 to the annuity company pays it to me. The other $250 that's in her IRA that's not yet taxable, you can transfer her IRA. We don't want to liquidate an IRA because you pay income tax on it all at once. You can transfer the IRA into a Medicaid annuity for IRAs. So she's got two annuities. And that IRA goes into that Medicaid annuity and pays to who? To me. So when we purchase those annuities, both of those annuities, my wife is eligible for Medicaid the next day, as opposed to paying $500,000 for 3 years. This is the use of Medicaid annuities. Questions about that before I get into the hypos? Just gonna. Yes, it can. What are you doing there? You're taking my wife's money and you are, instead of paying it in $12,000 chunks every month to the nursing home, you're buying annuities and gifting it to me, right? So we go back to the importance of having that power of attorney with the superpowers. Those powers allow for us to put the farm in my name. They allow us to purchase annuities because we're taking the money from the spouse that's sick and giving it to the healthy spouse. So I'm just going back to how critical that power of attorney is, because if we don't have those powers, we can't. There's all these tools that are in this toolbox to help people, but without that language in the power of attorney, you don't have access to the tools. You can't even go there. The question was, if you don't have a power of attorney, could you go through guardianship? So I should have mentioned this earlier. If I've talked about meeting with people that have a power of attorney and don't have the superpowers. Sometimes we meet with people that have no power of attorney, right? And they bring the person into our office to do a power of attorney for dad because he's getting old. and his capacity is gone already. So instead of spending a couple $100s on a power of attorney, we got to go to court and have a judge declare them incapacitated, have a doctor testify. I had one this morning. It's stressful, it's embarrassing for the person, and it's expensive. So the one I had today, for instance, we have the guardian appointed. And if you know anything about guardianship law, think about the fact this person is, they're incapacitated, right? So they are open for someone to take advantage of, right? And so whatever a guardian does with that person's money is monitored by the court system, because they can't watch over it like you and I would watch our checking account and see something bad. This person doesn't have the capacity to even watch their own money. So the guardian has strict rules about how they can spend money. So for instance, if you're a guardian, you have to get court approval to sell somebody's house. You have to go and have a judge say, I give you the power to sell it. Whereas under my power of attorney, I give my wife the power, she can sell it without a judge. We have had some success, right? Where we go to a judge and we say, this person has $500,000, it's going to go to a nursing home. And we want to buy these annuities. And the person doesn't have the power of attorney. And we go to court and sort of seek court approval to do Medicaid planning. I practice primarily in York, and we've had judges approve that. I cannot, I think there's definitely judges out there that would say heck no to that. And, you didn't get your proper planning in place. The person's incapacitated. So how do we know that this incapacitated person wanted the wife to get the house? Maybe he didn't like his wife. So that taking that leap of faith that that's what the person wants, I think a lot of judges would shoot that down. Good question. All the more reason to put this in place and not have that happen.
If you are able to do the annuities, successfully, then the income could result in the community spouse's income prior to the annuity income be totally used for care.
No. So how this works is that when, in my example, we'll go back to this. So back to these annuities paying to me, I'm the community spouse, right? And so first of all, these annuity payments are not income, okay? These are principal distributions. So I've seen annuities like a $250,000 annuity, the one on the right that's not IRA. I've seen that paid back over 1 year. So you give this annuity company $250,000 and they pay it back to me in 12 payments, okay? When those payments come back to me, they're not income. They're not subject to income tax. Remember, that's after-tax money to begin with. So there's no claiming of me receiving that money and having to pay income tax on it. Now, the IRA would be different. When the IRA makes payments out to me, I have to pay income tax on that IRA money because my spouse didn't. But going back to your point, if the money on the left is taxable and the money on the right isn't, that means the money on the left is income to me, the community spouse. The community spouse's income is not eligible for nursing home payments. The sick spouse's income is eligible for nursing home payments. Now I'll go back to my example where I said my income's $1,000 and my wife's is $3,000, and she goes into the nursing home and I get that $1,400 of her Social Security to get me to my MIMNA. When I start getting these big IRA distributions on the left that are income, when they come to me, now I don't have a MIMNA problem anymore. My income's like $10,000, $15,000 a month from these IRA distributions. I won't get that little $1,400 from my wife anymore. But the income, I'm going to stress this again, the income of the community spouse, whether it's pension, Social Security, or it's IRA distributions, that income is not lienable by the nursing home. It's the sick spouse's income. Medicaid annuities. Why are they not fraudulent transfers? Well, this is the rule on a Medicaid annuity. And as long as you meet these criteria, they are legal. I mean, I understand what this looks like. It looks like you're supposed to give this money to the nursing home and you buy annuities and give it to the healthy person. Okay. You don't have to be a rocket scientist to understand why people question this. So the annuity has to be actuarially sound. See if I have these memorized, which means that everyone that's here or in Zoom land has an actuarial expectancy that the IRS gives us. Okay. So if I'm 74 years old and I'm in a nursing home, let's say my life expectancy is 8 years. That means when we buy the annuity has to be 8 years or shorter. Okay. That's number one. Number two, the annuity payments have to be level, which means that each payment has to be equal. Can't have different payments each month. The prong that is the most scary, or the one that I think answers your question, is when you buy an annuity, you name a beneficiary, like a life insurance policy. And when you buy one of these Medicaid annuities, guess who you have to name as the beneficiary? The Commonwealth of Pennsylvania. So to your question, why is this allowed? It's allowed because if the person dies, the annuitant, the community spouse, let's say I have a 2-year annuity and I die in the 4th month, the bulk of that annuity hasn't been paid out yet. And so there's a bunch of money in that that's payable to the state. So the state's saying, we'll let you do this, but you have to name us as the beneficiary. So what do you, then you think, well, how can we get around that? Because we don't want them to get the money. We make the annuities shorter. Would you agree with me that I am more likely to make it 1 year than 2? Everybody. Everybody is more likely to survive 1 year than 2. So the shorter you make the annuity, the less likely the person is to survive it, right? So it's interesting that it's life expectancy or shorter. So I don't want it to be 8 years, because if it's 8 years, I'll probably die within 8 years. I want it to be a year. And by making it a year, I get my payments back faster. With me? And when I get my payments back faster, the annuity gets tapped faster. And then there is no beneficiary to pay because the annuity's terminated. I think that's why they're not fraudulent. I've never seen a third-party creditor attack the transfer. I understand what you mean by fraudulent conveyance. And for the audience, the idea is if I owe somebody money and I know it, and I take money and I give it to my friend because I don't want them to get it, that's a fraudulent transfer. You're doing something in forethought of what you owe. I would be hard pressed to come up with an example of how a third-party creditor could attach to this. And I'll tell you why. Because you've received something back from this contract. When you get fraudulent transfers, it's like you gave your money away and got nothing back. And this example, I gave my money away to have it paid to my wife. So there's consideration there that I think would protect this. So back to scenario one, Jane is seeking eligibility for Medicaid. Her husband owns 200 acres of land worth $2 million and $500,000 of farm equipment. Joe uses the land and the machinery to conduct his farming operation. So this is a pretty simple example that we've sort of gone over already. In this example, we want to impoverish Jane, right? She's the one seeking care. And so we know there's no 5-year look back for spousal transfers. And so hopefully Jane has a POA, right? That has the gifting language that we need in order to put the equipment and the farm in Joe's name. That would cause this money to be protected for purposes of Medicaid application. It's exempt. And then secondarily, when Joe dies, Joe doesn't own it. Jane, sorry, I said that backwards. When Jane dies, Joe doesn't own it. And therefore, when Jane dies, Joe owns it. I'll get this right. And that means that Jane's Medicaid lien cannot attach to Joe's ownership of the farm and the machinery. Next scenario. Jane is married to Joe, must be the same people. Jane goes to a nursing home and will not return to their home. Joe continues to live in their home. The home and 50 acres will be an exempt asset for as long as Joe is residing there. If the home is transferred to Joe and Joe sells the home later, Joe is able to retain 100% of the sale proceeds. Okay, let's talk through that a minute. So if we have proper planning here, we have Jane going into a nursing home and we have this home with 50 acres and we will transfer it if possible to Joe. Now Joe owns that property and it's exempt because of the primary residence exemption. When Joe sells that money, he is the one that would own the money because he owns the house. He sold the house, she's not on it. So what you've done there, this can be dangerous, is you've taken this asset that is exempt because it's a primary residence and you've converted it to cash. So it's not bricks and mortar anymore. And there's an argument to be made that it's no longer exempt. We have had some success in, I would urge people to do this before you sell the home. I go to a Medicaid lawyer I know who works for the state in Philadelphia, and we tell him we're going to sell this house and we want approval for the husband to keep the money and it not cause ineligibility for the wife. And DHS will give you that approval if you put the money into an account. They call it a sequestered account. You put it into an account in the husband's name and he signs something that he'll never gift it. And if he agrees never to gift it and keep it, they'll let husband keep the money and wife not lose her eligibility. Again, it's so surprising that it's allowed, but it is. We would also change, Joe should have his estate planning documents carefully reviewed if he dies before Jane. So I'll talk about that in a minute. So when we put the house in the husband's name, we don't want the wife to inherit the house. And so now we change his will. I talked about this before. We're going to slide the kids up in the will or whoever is next and take the wife out of the will in case he dies first. One of the things that we always have to do, have a CYA on, is what happens if, so now I own this house and I own this money and my wife is in a nursing home and she's on Medicaid. And I, the healthy spouse, die first. When I die first, my will says I leave everything to my kids because we fixed that. In Pennsylvania, and this would relate to a farm as well, a spouse is entitled to 1/3 of one's estate. So if I write a will and I don't like my wife anymore and I want to leave it to my kids, okay, get rid of the nursing home. I just want to give it to my kids, not my wife. When I die, my wife gets a notice that she becomes aware that she's entitled to 1/3. So the spouse they file what's called an election and say, wait a second, I want my 1/3. Okay. So if I go back to my example, Joe has rewritten his will to exclude Jane and Joe dies first. Jane is in a nursing home. She has no idea any of this is happening. But because Medicaid is paying for Jane, Medicaid requires her to go get her 1/3. Okay. So whether it's a POA or a guardian, they have to put their hand up for Jane because Jane can't herself and say, we want our 1/3. If you don't make that election and you're on Medicaid, you lose your Medicaid because that's a gift, right? If you're owed a 1/3 and you're on a government benefit, you got to go get your 1/3. If you say, I don't want it, you gave away your 1/3. So you have to pursue the spousal election. Scenario 3, Bill owns 500 acres of farmland that he wants to protect from long-term care costs. He has other sources of income and does not need the income from the farmland. He establishes an irrevocable trust and transfers the 500 acres into an irrevocable trust. right? We talked in the beginning, revocable trust, this would do nothing. If he puts it in a revocable trust because he can get it back. This is irrevocable. The trust states that the land shall be held in trust for Bill's life. Basically, the land's not supposed to be sold until Bill dies. And perhaps afterwards, it's not to be sold. You can even have language in trust to try to prohibit sales, not necessarily forever. But ultimately, while he's alive, it's not sold. If there's income from the farm's in the trust, therefore the income's in the trust. The income pays out to his two kids, not to him. If we have the income payable to him, then the nursing home could take it, right? Upon his death, the land is to go to his two children. If a child predeceases Bill, the child's share will be distributed to their children, provided they're 25. So first of all, we have ding, 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 a 5-year look back problem, right? So when he put that farm in the trust, okay, we want to, hopefully he made it 5 years without needing skilled care. And if he did need skilled care, what does he have left? This hypo seems to indicate that he has other sources of income and other money, perhaps, right? So one of the ways this works a lot is if I put my farm in a trust and I have $500,000, right? And then I go into a nursing home. I can use my $500,000 to buy me through the 5-year look back. Okay. And so I'm saying I'm not applying for Medicaid yet. I don't want to apply for Medicaid. Why? Because I have a 5-year look back problem. I don't want them to see this. And so I want to make sure I can get to 5 years and then apply. And now the gift into the trust happened more than 5 years ago. And if the gift to the trust happened more than 5 years ago, there's nothing that can be done. It's out, right? So hopefully in this scenario, Bill has requisite income and savings to buy him through the 5-year look back if the transfer happens within 5 years. So, what happens if he doesn't have any money? Okay. And there's a 5-year look back. Well, now we have some problems, right? Because he put this expensive farm into a trust and he didn't make it 5 years. There can be the opportunity to sell the farm, which is not what any farmer wants to do, to create cash, to fill up that hole, right? I know that's not what we want. That's not what this program's about. You could hypothetically, and this is interesting that this is allowed, but Pennsylvania has some statutory authority to revoke an irrevocable trust, which sounds confusing that you can revoke what's irrevocable. But when you have everybody that's sort of involved in it, like the kids agree and dad agrees, we could potentially get the farm out of the irrevocable trust and back to dad and cure the 5-year look back. So now he owns it and fix that. Now, if the kids say, I'm not signing off on that because I want the farm and I don't want to help my father, then we can't revoke what's irrevocable. I think we have a couple questions here.
Yeah, if we can go back to number 2, the last comment was, since trust assets are not probated, set the trust up instead of just checking will.
It depends what type of trust you're talking about. So remember that I would agree with you that irrevocable trusts are not subject to, I think you're trying to get away from the recovery here. So if you put money in an irrevocable trust, I would agree with you that it's not subject to recovery. But if money is in a revocable trust, I think it is subject to recovery because revocable trusts are known to be will substitutes. Joe has $50,000 of annual income and $400,000 of savings. So Joe's got some money. And this seems to be that Joe has no spouse. His only other asset is farmland. Joe is reluctant to gift his land to his children in case they have financial difficulties and are forced to sell it. We talked about that earlier. If you gift something to someone, they can do whatever they want with it. So if he gifts it to his kids, maybe they sell it. Maybe that's his fear. He is also reluctant to transfer his land to an irrevocable trust because he does not want to give up ownership and control of the land. Also, if you've ever dealt with trusts are expensive to run. You have to file a tax return for a trust every year. You potentially have to give accountings. You have to pay attorney fees, accounting fees. So trusts can get expensive. So what we have here is Joe has some money and a farm. Joe does not want to give his farm to his kids yet, and he doesn't want to put it in a trust yet. He wants to keep his farm. So you'll hear this called the wait and see approach. So the wait and see approach is a great approach if you have money. So if you don't have any money, that doesn't work. So Joe holds on to his farm, and then we'll add to some facts here. A year later, he develops dementia and he goes into a nursing home. Okay. Well, now there is an ability to transfer that farm to his kids at the time that he's even going into the nursing home, because he maybe has enough or close to enough to pay for the 5 years, right? So we gift the farm to the kids or into a trust, hopefully using a POA because he's incompetent. Going back to the POA thing again and again, we don't have the POA, we can't do this. So now the kids own the farm, and we're using his $400,000 and his income to buy through the 5 year. Now, in my experience, at least around here, that would be a little light for 5 years. I think projections I use $650,000, $700,000 for 5 years in a nursing home. So, what if I were, you start to deal with the kids then on his behalf, and you say, look, you're getting this $1 million asset, right? And your dad's got 450. Although, that annual income of 50, I suppose we need to multiply that out, right? So that's not 50 grand, it's 250 grand because it's over 5 years. So now he's more like 650. But we've had to have talks with children where you say, dad's short a couple months to get us to the 5 year. So if you're going to get $1 million farm, kid, how about you pony up 20 grand and buy us through those last 2 months? Sometimes you need to get the family together to understand everybody has to commit to this plan. I'll go back to the chat box. 1 second, please. So this is sort of the wait and see approach, which again, doesn't really work if Joe has no money. Scenario 5. Mike and Nadine own 5 farms. One farm, the Smith farm, is farther away than the others. It's a less productive farm and recently purchased. Mike and Nadine decide if they need long-term care and do not have income or savings to cover the cost, they will sell the Smith farm to pay for their care. So I think that sounds like they're actually sort of using that one farm as long-term care insurance. They're saying if we have to go to a nursing home, that's okay if we sell that one to cover our costs. Mike and Nadine let the family know of their plan so that everyone is aware the Smith farm is the long-term care insurance plan. So, yeah, I mean, those are very specific facts of multiple farms and having one that you're willing to part with. Most people don't have 5 farms and most people don't want to sell any of their farms. So those are unique facts. But, one thing I would say about that is you definitely want to know how much the Smith farm is worth, right? And when you're doing this type of planning, if you want to do worst case scenario planning, you're actually doing planning for 2 spouses. So if I'm saying that 5 years in a nursing home costs $600,000-$700,000, if both spouses would require long-term care, we're talking 1.2, 1.4 to make sure the Smith farm is worth that much down the road. Scenario 6. This one is a little complicated. This is probably the most complicated of them. That's probably why it has 2 slides. But so Joe, I'm going to use junior and senior here. So junior, we're going to have grandfather, we're going to have son, and then grandson. So junior is the middle. Junior's 55 and his son 27 is the grandson, work on the 200-acre family crop farm in northern Pennsylvania, and they co-own the equipment. Okay, that's a little bit of a red herring, but let's say that right away, who owns that equipment? The son and the grandson own it. Okay, so that if that's actually titled correctly and owned like that, that's not an asset of granddad's, right? So we can sort of peel that off and say nobody gets that. While Junior's wife, Jane, handles the bookkeeping for the farm. So that it sounds like son, grandson, and son's wife all work at the farm. It's no longer feasible for the family to care for Senior at home. He has entered a local nursing home due to dementia and increased physical needs. Jane calls your office and requests a meeting. Junior, Jane, and Joe are concerned about how to keep the nursing home from getting the farm because the deed to the 200-acre family farm is still in Senior's name. Jane reports that Senior has about $70,000 in a savings account, a small house on the family farm, and a pickup he drove until his dementia set in. His wife passed away 6 years ago. Senior does not have long-term care insurance. Junior and Jane live on the farm in a larger home, and Joe and his wife live off the farm. Farm operations are run from the family farm. Junior, Jane, and Joe rely solely on the farm for income. That's a big need there. And their goal is to save the family farm. In Senior's will, the farm transfers to Junior and Jane. Okay. So here we have some immediate things that stick out. The fact that Senior has $70,000 is a 5-year look back issue, right? Unlike the prior slide, the guy had $400,000 and 50 grand a year of income to buy him through. It appears that Senior doesn't have enough money to buy himself through 5 years. So a gift right now would not be a good idea, whether it's to Junior or to a trust. So what else do we have out there? Some things to look at would be, was son Junior helping to take care of dad? Okay, we go back to that caregiver exception in the letter from the doctor. And, maybe you have a friendly doctor there, maybe the facts are good, but if we can say there was a 2-year caregiving exception that son, because we have the facts that Junior lives on the farm, okay, because the son's got to live there to get the caregiver exception. If he's providing care, maybe we can deed it to Junior with the doctor's letter and not have a 5-year look back issue. Another option in some of these cases is to try to have the beneficiary son, in this case, buy into the farm. Okay. So if we were able to get this appraised and we were able to have son buy in to a portion of it, remember, we're going back to the fact that this property is exempt. Okay. This is the nursing home can't get it when he's alive, but we don't have a wife to give it to. So when dad dies, it comes in his estate and is subject to recovery. So is there a way, if we can't use the caregiver exception, can we somehow get son on the deed? And if we can't do it through a caregiver exception and we can't do it through a gift, the only way to get son on the deed is for him to pay to get on the deed. Okay. Not the whole value, but if we can get him on the deed and we can have 2 names on the deed, then when dad dies, the farm will transfer to son and not come into dad's estate. So if we can get son to buy into the farm, we can have the farm passed to son, non-probate by joint ownership outside of the will, and then no recovery by Medicaid against the farm. That would be another option there for him to buy a percentage of the farm. Let's see what we have here in the chat. So, yeah, somebody asked about using an LLC or a partnership. That we haven't talked a lot about that. So, the issue in this case is it too late to do that? Is a transfer into an LLC in which dad is making his son even a minority owner of the LLC or member, or dad can be the general partner of a partnership and son could be the limited partner. Those are effective strategies because why? Because if the farm is owned by an LLC or a partnership, those are business interests. Okay. And so business interests are exempt from Medicaid. Okay. But let's take that a step further and say, great, we made it exempt because it's business, but didn't we have an exemption anyway because it was income producing? Yeah, we did, but here's the difference. If it's owned by an LLC or a partnership, we can use the LLC agreement or the partnership agreement to explain where dad's LLC or partnership interest goes when dad dies. And if you have that interest passing under that LLC agreement, it could be argued it's not in dad's probate estate and it's not subject to recovery. So I think you could probably, for all these scenarios, incorporate some sort of LLC or partnership suggestion, but you still have to be wary of the 5-year look back in doing that. If I say, wait, I gifted to my son, that's a gift, that's a 5-year look back problem. Okay, then I gifted it to an LLC, that's still a gift. If you gift it to a trust, it's still a gift. So we have to be wary of the 5-year look back, even for LLC and partnership transfers. Good point. Scenario 7. Mary wants to save the family farm for her brother, Anthony. He's a 67-year-old dairy farmer who continues to live on, important, and farm the 145-acre dairy farm in Southwest Pennsylvania. Anthony's farmed it for 49 years old, or 49 years with his brother, John, who died from COVID in 2021. Now Anthony farms with his nephew, John's son, Rex. Rex prefers to do the crop work, but isn't interested in the cows. Their dad passed away 2 years ago, and the farm is solely in mom's name. Okay. However, Anthony has been caring for mom since dad's death. Thank you. I must sound hoarse. Thank you. So what happened? Dad died, and mom is surviving, and mom is sick. And the facts lend itself, perhaps intentionally, to the son living there. So he lives there and he takes care of his mother. And so ding, 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 we have a caregiver exception, right? And so we have this potential to get the doctor's letter and transfer deed from mom to son without any 5-year look back. This one has a second slide to it that has a potential for a family issue. So let's continue on. Mary wants to help save the farm for Anthony because he's only ever farmed. Along with the farm work, he cared for his ailing mother and father. We talked about that. Even income that he made from doing the work, he put back into the farm. He's a good son. Mary seeks to ensure Anthony can continue to farm and the farm will stay in the family. However, she can't buy it. Mary is concerned that holding on to the farm may be a challenge. Well, excuse me, when mom passes, her will leaves the farm to the 5 kids. Okay, so here is the bugaboo. If we give the money, or excuse me, the farm to Anthony because he's the only one that qualifies for the caregiver exception, the 5 kids didn't get the farm. Anthony did. And maybe Anthony deserves it. Maybe he's the only one that worked there, but that's not what mom's will says. So those are things that we try to get our arms around early and often before this thing blows up and everyone's fighting. One of the things we could do is get Anthony to agree that after he gets the farm, he will add his siblings to the deed. We can't put the siblings on the first step of the deed because they didn't do the caregiving, but Anthony could add them later. Okay. Maybe Anthony buys them out later. But those are things that you would want on board when you do this. And interesting thing here to think about, I go back to these superpowers, maybe end with this, these superpowers. So the one in my power of attorney says that if I go into a nursing home, I want my money to go to my wife. And then if my wife is dead, I want my money to go to my 3 kids. So not only do my superpowers give the ability to make the gift, they identify who gets the gift if it ever happens. I don't want it going to my wife's new husband. I want it to go to my wife, and if not her, then to my kids. So I build that into the power of attorney, and I handcuff where my money's going. And so query, if her power of attorney has the gifting power, and it says, I allow for gifts to be made to my 5 children, like my will says, right? We have a problem here again, because we're making a gift to one of them. Now, perhaps we could argue that we're going to get it there on the second deed, but that has some interesting facts to it. Okay, maybe I can cram one more in here. We got 5 minutes. Scenario 8. Anne is a 49-year-old single mother and farmer, and she owns a 100-acre Pennsylvania fruit farm and wants to be proactive in her planning. She's 49. She is partners with her 2 adult daughters, Diane, 27, and Maggie, 25. Her daughters manage the heavy field work, while Anne manages the farm store and handles the bookkeeping. The farm deed is in Anne's name, so mom owns it, not the girls. I think that I don't know why we have the term partners here. That would invoke that maybe there's a partnership, but it says that Anne owns it, not the partnership. So I think their term partners means they just work together. And she owns most of the farm equipment because the girls have young families and other priorities for their money. While Anne is healthy, she knows she needs to plan for the unexpected and her needs as she ages, while keeping the farm and equipment safe from Medicaid liens. She doesn't have a lot of savings, but she has been able to put away some money for emergencies. She's seeking advice on the best options for the farm. So what do we have here? This is a good example of perhaps the ability to use an LLC or a partnership, as we talked about previously. We don't hopefully have a 5-year look back issue with a 49-year-old person. And so we have time to make some transfers, give some equity to her daughters, and still have some control over this. One of the differences in simply adding the girls to the deed would be that they outnumber her, right? So she adds them to the deed, they vote against her, they sell it, they kick her out. So using an LLC or a partnership, we can give the girls ownership, but give control, have mom retain control, use a business exemption there, and hopefully avoid recovery. Okay, well, I don't know that we need questions and answers because we've been answering questions the whole time, but my information is included in your materials. And if you have any questions at all, you can always shoot me an email and I'm happy to answer you. And I'll step aside now.